call the August 22nd, 22 meeting of the Board of Appeals to order. Our first order of business is board reorganization. We do need a vote for a chairperson and a vote for a vice chairperson. Do I hear a motion?
Motion,
Motion for,
chairperson.
And-
Diane.
all right. Do I have a second? All right. All in favor of the motion signify by saying aye.
Aye.
Aye. The vote carries. I assumed you said aye.
Yes, ma'am.
Okay, I didn't hear you, but
You have your mic on?
thank you very much. Yeah, it's red. When it's red, the
There you
mic
go.
is on.
Sorry, Scott. I should have told you that.
There you go. And Dan, you won't be able to formally vote, but please participate, ask any questions, whatever you'd like to do. All right, do I hear a vote for a chairperson? Do I hear a motion for a chairperson?
Motion,
Yes, Wayne?
Wayne Slaughter.
All right, I hear a motion for Wayne Slaughter to serve as vice chairperson. Do I have a second?
Second.
All right, a second by Scott. All in favor of the motion signify by saying aye.
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 Aye. The vote carries. All right. Now we don't technically have someone on the agenda to serve as a note taker. But Scott, would you be willing to serve that function for us for the next year?
Sure. My understanding is it's recorded and I can do that after the fact.
It is recorded. It's always a good idea just to take little notes. I find it helpful, but
Okay.
yes, it is recorded and you can do it after the fact. And as you notice, we'll go over the minutes here and make any corrections to it. So, all right, our next order of business is approval of the minutes from our regular meeting on October 18th, 2021. Did everyone get a copy of the minutes? Okay. Are there any corrections or additions or subtractions to the minutes?
None on my end.
All right. Zach, I had a couple little minor spelling mistakes.
Oh,
Can
sure.
I just hand those to you?
Sure.
All right. Do I hear a motion for the minutes of the October 18th, 2021 Board of Appeals hearing minutes to
Motion
be
approve the minutes.
motion to approve the minutes? Do I hear a second?
Second.
Motion's been made and seconded to approve the meeting minutes, October 18th, 2021. All in favor signify by saying aye.
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 Aye. The motion carries. Zach, I will just leave those for you.
Sure. Thank you.
All right, nothing big.
Great.
All right, we're not going to wear the witnesses, but we will swear them in, so. If you could stand, please. Anyone who's expected to speak or testify at the hearing. All right,
You guys,
raise your right hand.
you don't have,
We don't have to do that.
Raise your right hand. Do you solemnly swear or affirm under the penalty, Leslie, I believe you're going to be speaking, right?
Right, but I'm not testifying. This is this is a source of constant confusion among boards.
Oh, good.
I'm happy to be sworn in if you like, but I'm providing you legal advice this evening, not factual testimony, but I'm happy to participate.
Okay, well, I'm going to cross out that thing that says all present, including attorneys. So
So, that's what it goes
Yeah.
to.
Oh,
the applicant.
if they
So
had-
they have to-
if they had counsel,
Right,
gotcha.
exactly.
All right, raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the response given and statements made by you in these proceedings will be the whole truth and nothing but the truth? If so, state I do.
I do.
Thank you. Please be seated. Now, I'm going to explain something. My pump is beeping. Did you guys hear it?
Yeah.
Yeah, this is my insulin pump, so it's complaining at me.
Too low.
No, fortunately, it's not too low. It just didn't take my calibration before, which it should have.
That's the problem when it's CGM.
So let me just correct that right now, because otherwise it will continue to become very annoying. All right. Thank you, everyone. Sorry for that. Zach, I don't believe we have any old business that I'm aware of. Is that correct?
That's correct, Madam Chair.
All right, thank you very much. New business. We have the only case on the agenda is the case of Robert and Valerie Turnquist. And it's the application of the Turnquist for property located at 4,000 Carrick Court, in which the applicant seeks a variance for the 5 to 6 foot tall fence to remain in the front yard facing Brookfield Drive. All right. We will have the planning staff present the case.
Thank you, Madam Chair. I'm going to read off of the staff memo that was presented to the board, and we can enter this into the record as Exhibit 1. We did advertise as required in the code in the Frederick News Post on August 1st and August 8th, 2022. The property was posted on July 13th as required by code as well. The applicant constructed, this is a little bit of a background. The applicant constructed a 5 to 6 foot tall fence, which varies in height in the front yard of their property without town zoning permit approval. According to page 1 of the Board of Appeals variance application package, the fence was installed on June 6, 2022. The town code enforcement officer issued the homeowners a code enforcement door hanger on June 7, 2022, stating that they must apply for a zoning permit for the newly installed fence in accordance with Town Code 1748020. The applicant applied for a fence permit on June 10th, 2022. The town zoning administrator, which is myself, denied the zoning permit application on June 13th, 2022, as the fence does not meet the requirements set forth in Town Code 174060B, as in boy. A copy of the zoning permit denial letter is located within the applicant's variance application package. The applicant has requested a variance to the following category in Title 17, Chapter 1740, Section 1740-060B of the town's codified ordinance. Allowable projections of fences into yard. The requirement per the code states no fence more than 4 feet high may be located closer to the front of the lot than the principal building. Requested variance allow a 5 to 6 foot tall fence to remain in the front yard facing Brookfield Drive. Town code variance requirements in 1712-050B of the code states no such variance in the provisions or requirements of this title shall be authorized by the board unless the board finds beyond reasonable doubt that all of the following facts and conditions exist. So I'm going to read the 3 conditions and I'm going to read staff's input on that.
Okay.
So number 1, that there are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes of uses in the same zoning district. Staff comments. Number 1, the variance application is the result of a self-created hardship. According to the applicant, under background on page 1 of the application, neither the fence contractors nor HOA informed them that a town zoning permit was required for the project. If the applicant would have contacted the town before installation, staff would have informed them that a fence over 4 foot tall was prohibited within the front yard and a zoning permit was required per Town Code 1748020. It is the responsibility of the property owner to obtain any necessary permits before construction. Number 2, I won't read all the specific details of linear footage, but I'll state the properties.
Thank you, but they are in the
Packet, correct. There are 8 corner lots in Pembroke Woods subdivision, all of which are very similar in size, shape, and slope. So it does not seem that there are exceptional or extraordinary circumstances or conditions that apply to the property in question that do not apply generally to other properties or classes in the same neighborhood or zoning district. Most, if not all, the properties in Pembroke have a sloped front, side, and rear yards or rear yards due to stormwater management swales. Those addresses that I found were 4,000 Carrick Court, 4,005 Carrick Court, 2,000 Pembroke Court, 2005 Pembroke Court, 3,000 Stonehurst Drive, 3005 Stonehurst Drive, 3010 Stonehurst Drive, and 3025 Stonehurst Drive. Number 3, the applicant mentions Town Code 1504-010 on page 3 of their application, which does not apply. A Frederick County building permit is not required for a fence installation. Only a town issued zoning permit is required for a fence installation. Number 4, the applicant mentions Frederick, Maryland Land Management Code Article 8 Supplemental Use Regulation, Section 821 on page 4 of their application. This does not apply. Frederick County does not have zoning jurisdiction within the town corporate limits. All right, so number 2, that such variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. Staff comments, the reasons for the fence do not appear to be supported by evidence that such a fence would provide sound reduction or reduce water runoff through the lot. To the extent that the fence interferes with the swales for stormwater runoff, such interference is not permitted under the code. No evidence is provided that the addition of the fence preserves or promotes property rights enjoyed by others in the subdivision. And then the final requirement, number 3, that the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of this title or public interest. Staff comments, it does not appear that the fence will cause substantial detriment to adjacent property and will not materially impair the public interest. It also does not appear that the fence is within the Carrick Court, Brookfield Drive intersections, clear sight triangle. However, this should be confirmed by an engineer or a surveyor. Approval of this variance could set a precedent which could materially impair the purpose of Title 17 zoning. If approved, property owners could regularly request variances for the placement of 4-foot plus high fences in the front yards. 3, this issue could be addressed by amendment to the fence ordinance that would apply to all lots within 2 front yards and does not appear to result from a unique characteristic of this lot. And as always, we do provide a suggested motion, move to approve or deny the applicant's request. Regardless of the outcome, please state your findings of fact and reasons for the grant of the variance for the record. The findings of fact shall provide specifics supporting your determination on how the applicant meets or does not meet each of the town code variance requirements set forth in 17-1250B. To approve, you first must determine whether the property is unique and unusual from the surrounding properties, and the uniqueness of the property causes the zoning provisions to impact the property disproportionately. If this determination is not made, your analysis ends. If you find that the property is unique, you then address whether uniqueness causes a practical difficulty or undue burden if the zoning provisions is applied. Each of the above factors must be met and supported by evidence. Conversely, if you find that the factors are not met, the facts in support of your determination must also be stated. And if approved, staff recommends at least one condition of approval, that the applicant shall provide a letter from a certified engineer, Maryland, stating that the location of the fence is not within the Carrick Court, Brookfield Drive intersections, clear sight triangles, and triangle, and meets the requirements set forth in Town Code 1708-160, clear sight triangle site distance. The fence shall be moved out of the clear sight triangle if applicable. And that's my presentation.
Okay, thank you, Zach. I appreciate that. We'll now hear from the applicant, Valerie, and or Robert Turnquist. When you come up to the microphone, please turn the microphone on and state your name and your address, even though we all know what it is.
Madam Chairman, board members. My name is Robert Michael Turnquist. I reside at 4,000 Carrick Court, Emmitsburg, Maryland. My family and I have lived there for a little over 12 years. Getting to the request for variance. In the spring, we received 3 requests to replace a dilapidated split rail fence in our yard. The quotes were for a 6-foot Williamsburg picket fence and obtained bids from Long Fence Company. Frederick Fence Company and Armor Fencing. Architectural approval from the Pembroke Board of Governors Association was approved by the Board of Directors. Based on price and installation schedules, a contract was executed with Armor Fence. We asked Armor Fence if a permit was required, and they said no, it was not. But we were notified that we were to call Miss Utilities, which we did, and they came out and did their markings. Neither the HOA nor the three companies that provided quotes informed us of the 4-foot fence regulation. In fact, the president of our HOA said the fence looked great. Armor Fence has a AAA rating with the Better Business Bureau. On June 6th, the fence was installed on our property, and on June 7th, we found a notice of code violation on our front door stating that a zoning permit was required for the new fence. On June 10th, 2022, we submitted the permit request to the town of Emmitsburg. In the afternoon on this date, Mr. Golden came to our residence. He informed us, my wife and I, that he planned to disapprove the permit application. He explained the procedure to request a variance and said that we would have to pay $400, and win or lose, we would not get that money back. At this time, I'm going to have my wife take over and do some further comments.
Thank you.
Switch off here and there. And
Okay, no
Fine,
problem.
thank you.
I'm Valerie Turnquist. I live at 4000 Carrick Court, Emmitsburg. The town code variance requirement 17-12-050B of the code states no such variance in the provisions or requirements of this title shall be authorized by the board unless the board finds beyond reasonable doubt that all of the following facts and conditions exist. So I'd like to go through those 3 conditions. Condition number 1, that there are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes of uses in the same zoning district. So our property is located on a corner lot in the Pembroke Woods subdivision. The legal front of the property faces Carrick Court, while the side abuts Brookfield Drive. Carrick Court is a cul-de-sac and therefore not a major thoroughfare. The front of the property that faces Carrick Court is 102 feet wide, while the side that abuts Brookfield Drive is almost double that. And that should be on your exhibit 1 if you need that for reference. So our property is long and narrow and slopes upward considerably from the road being Carrick Court. This is also true for the new homes built directly behind us in Brookfield. They are at a higher elevation than my property, also exhibit 3. This is unique from other corner lots in the subdivision. The sloping topography and corner lot designation creates the hardship of limited use of the land if a variance were denied. The application of a zoning ordinance to the unique characteristics of the property creates the need for the variance. The zoning ordinance impacts upon the land in a unique manner that does not exist where restriction applies equally to all lots of similar size. So Zach had read the staff comments saying that basically he ends the first comment with, it is the responsibility of the property owner to obtain any necessary permits before construction, and this was a self-created hardship. So my response to that is the Maryland Department of Labor, Maryland Home Improvement Commission states that it is the obligation of the prime contractor on a home improvement project to A, obtain all required building permits, or B, to make sure that all permits have been obtained. COMAR, Code of Maryland Regulations 9080108, duty of prime contractor on home improvement contract states, in the performance of any home improvement contract, it shall be the non-delegable duty and obligation of the prime contractor to secure or see to the securing of every permit, license, or special exception necessary to the proper completion of the contract according to applicable state or local building laws. Furthermore, if we were to pull the permit as the homeowner, we would be fully responsible and liable for the work. So the next staff comments, there are 8 corner lots in the Pembroke Woods subdivision, all of which are similar in size, shape, and slope, blah, blah, blah. And Zach will then list the 8 properties, which he read earlier. So Mr. Golden mentions that the 8 corner lots in the Pembroke Woods subdivision are all similar in size, shape, and slope. So let's take a closer look at those properties. Number 7 and number 8 on Stonehurst Drive and Stonehurst Court are very different than our property at 4,000 Carrick Court. These properties do not front a public road, e.g. Brookfield Drive. They do not have public sidewalks on either side of the property. It's also not a through street that connects Irishtown Road to Tract Road. Stonehurst Drive leads to 2 cul-de-sacs, resulting in less traffic. In addition, these 2 properties have a fence in their front yard that's greater than 4 foot tall. That leaves 6 corner lots in the Pembroke Woods community to talk about. Number 2, 4,005 Carrick Court has half of the linear footage fronting Brookfield Drive, and the lot is relatively level. Number 3, 2,000 Pembroke Court faces Brookfield Drive, which is different than the other lots mentioned. They would therefore not install a 6-foot fence facing Brookfield Drive, which would be in their literal front yard. This lot is also relatively level. Number 4, 2005 Pembroke Court has less frontage on Brookfield Drive. They currently have a 6-foot fence in both yards facing Brookfield Drive and Pembroke Court. Number 5, 3,000 Stonehurst Drive is a smaller lot that is relatively level. Number 6, 3,005 Stonehurst Drive is also a relatively flat lot. This property also has a greater than 4-foot fence in their front yard. These properties do not have the extensive depth and length of the stormwater management system drainage that 4,000 Carrick Court has. They also do not have new homes built behind them at a significantly higher elevation. The lot is unique as compared to other lots in Pembroke Woods. Our property borders the Pembroke Woods subdivision along Brookfield Drive. There's a walking path directly across the street from our home on Brookfield. This particular area is utilized by pedestrians, people walking their dogs, bicycles, school buses, and traffic in general. Therefore, the area is more heavily utilized than other blocks in the Pembroke Woods subdivision. That would conclude condition number 1. So condition number 2 of the variance, that such a variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. The proposed fence's 6-foot height is requested in order to provide both a sound barrier and for increased home security. Both of these concerns are due to the proximity of Brookfield Drive, which my property abuts. The requested variance would provide a security barrier and reduce the noise level in the home. My husband here with me today is a 73-year-old disabled veteran, and we have 2 small dogs. There have been instances where our terrier jumped over the old split rail fence. In these instances, my husband is unable to get to him in time to keep him contained in our rear yard. We are afraid of him running into the street and being hit by a car. There's also been a case of an elderly gentleman from the Brookfield development that walks on the sidewalk adjacent to my property on the Brookfield side, and he throws rocks over the fence at my dogs. The 6-foot fence also encloses a play yard for my granddaughter who lives with us, as well as a small lawn shed. Due to the construction of new homes and increased traffic along Brookfield Drive, I am concerned for my granddaughter's safety and that of my property, with not only the additional foot traffic, but also the increased traffic coming from Tract Road and Irishtown Road. Brookfield Drive was previously a dead-end street with no access from Irishtown Road. While the posted speed limit on Brookfield Drive is 15 miles per hour, cars are often reaching speeds over 35 miles per hour, including school buses and commercial vehicles. More recently, we had a large black bear next to our home. A 6-foot fence would deter wild animals from crossing through our yard. I posted an alert on the Pembroke Woods Facebook page to alert others in the community to be aware of that. Exhibit 8. The construction of new homes in the area has created a situation where wild animals have been displaced and are having to relocate. The additional 2 feet of fence height will substantially improve the privacy, security, and comfort of the functional rear yard of the property. The height would help to mitigate the visual and noise impact of Brookfield Drive. The enforcement of the ordinance would only permit the 4-foot fence, which would adversely impact our ability to use and enjoy the property. Approval of this variance is necessary for the preservation of substantial property rights possessed by other property owners in the same subdivision. There are at least 4 additional homes in Pembroke Woods on corner lots with fences over 4 feet high, and those property owners are enjoying the substantial right of security and privacy on a daily basis. There are additional homes in Pembroke as well as Emmitsburg that have fences greater than 4 feet tall in their front yard as defined in the reference town code. To move my fence back to the building line of the residence would cause a loss of square footage in my rear yard totaling 2,706 square feet. An equally important need for this fence is to ensure harmony and peaceful coexistence with our neighbors with regards to our dogs. There are pedestrians walking and running along the sidewalk that runs the length of our property on Brookfield continuously all day. Homeowners constantly walk their dogs on the sidewalk adjacent to our property of which they're entitled. My dogs begin barking and running back and forth along the sections of the old open wire fence that they can see through. The 6-foot fence, the 6-foot wood fence provides a semi-private view of the sidewalk as well as our property. Literal enforcement will result in difficulty or unnecessary hardship and poses safety concerns and risks. As a homeowner, I would experience practical difficulty each and every day in keeping my grandchildren and pets safe and free from harm. Staff comments to that were, the reason for the fence do not appear to support by evidence that such fence would provide sound reduction or reduce water runoff through the lot. No evidence is provided that the addition of the fence preserves or promotes property rights enjoyed by others in the subdivision. So in my research, because sound waves do not travel in a perfectly straight line, a taller fence will help reduce significantly more noise than a smaller fence. The other way noise reducing fencing works is through its mass. The more solid a fence is, the more sound will be blocked. Split rail fences don't add to the privacy or security of your home. While split rail fences can more concretely define property boundary lines, it is not a practical deterrent against intruders or wildlife. Those homes not on a corner lot can have a 6-foot fence in their rear yard. There are other corner lots that have a 6-foot fence, and we would like to enjoy the same property rights afforded to other residents in our community.
Excuse me.
No problem.
Condition 3, that the authorizing of such a variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of this title or the public interest. First, there is no indication that a fence greater than 4 feet will have a negative impact on other homes along Brookfield Drive, and it appears that a higher fence in this location is valued for the greater privacy, safety, and travel noise mitigation it provides from the adjacent Brookfield Drive. It was our intent to create a fence that specifically blends in with not only the existing landscape and vegetation, but also in complete harmony with the neighbors' fence types and appearance, which is shown in Exhibit 11. Second, the space between the dwelling and the lot line abutting Brookfield Drive, although technically defined as a front yard due to its corner lot status, in fact serves as a property's rear yard. Rear yards are typically permitted fence heights up to a maximum of 6 feet. While the purpose of this ordinance is likely to minimize the impact of the fence located at the actual front of the property, in this case, the fence would separate the dwelling's functional rear yard from an adjacent arterial road. Third, the character of Brookfield Drive has changed substantially since the home's construction. The use of Brookfield Drive as an access road from Irishtown to Track Road has increased significantly since Brookfield Drive was opened up as a through road. Before that, the volume of roadway was significantly lighter when Brookfield Drive was a dead-end street. The ordinance is supposed to limit the height of fences for the rear yard area on corner lots. Most would consider Brookfield Drive at the rear of my house, and it is only because of a technicality that is considered a front yard. Before installing the 6-foot fence, I spoke with my adjacent neighbors. The adjacent neighbor on Carrick Court benefited as I paid to remove the shared fence, which was rotten. The new neighbors adjacent on Brookfield Drive and to my rear gained a level of privacy not previously afforded. The proposed variance does no harm to either public or private interest, is not injurious to any property or interest. In fact, granting the proposal variance will serve only to create a more pleasing visual harmony by virtue of the architectural design required by the Pembroke Homeowners Association. Additionally, the proposed fence that this variance is being requested for does not encroach or infringe on any neighboring residential properties, nor would it impose any hardship on any neighbors, nor would it serve to create a situation where any neighbor's quality of life, property value, or peaceful coexistence will be negatively affected. Quite the contrary. Excuse me. The proposed variance would allow me to become a quieter neighbor, enjoy greater personal security, privacy, and achieve a power noise level in my home. Staff comments. Oh. Technically, corner lots have 2 front yards. However, the 6-foot fence is clearly in the rear of the property and what's considered the backyard. By meeting the conditions of the town code to a variance, a precedent would not be set.
No rush.
The last part of our statement, we were just gonna share as part of the rebuttal. After we hear any comments from anybody on Zoom or.
We can now open the meeting to the public. I don't have anyone signed up. There's obviously no one else in the room. Did we hear from anyone on Zoom, Amy? Okay, no one has requested to speak. All right, and they would have had to have been sworn in anyway at the beginning. I suppose I could have sworn them in now, but all right. So we don't have anyone from the public who wants to testify. Would you like to give your rebuttal now?
Yes, I'll go ahead and wrap it up.
All right.
Hopefully wrap it up. Town Code 1712.40, power of the Board of Appeals. The Board of Appeals can hear and decide appeals where it is alleged there is an error in any order, requirement, decision, or determination made by an administrative official under the provisions of this title. To hear and decide special exceptions in the terms of this title. To authorize upon appeal in specific cases such variance from the terms of this title as will not be contrary to the public safety, health, and welfare and will most nearly accomplish the purpose of this title. Appeals Code 1712.030C, the concurring vote of only 2 members of the board shall be necessary to reverse any order, requirement, or decision or determination of the zoning administrator, or to decide in favor of the applicant upon any matter which is required to pass under such ordinance, or to effect any variation in such ordinance. 1712.060, limitations, guides, and standards for special exception. Where in this title, certain powers are conferred upon the Board of Appeals, such board shall study the specific property involved and the neighborhood. The application shall not be approved where the health, safety, security, morals, or general welfare would be adversely affected, or would result in dangerous traffic conditions, or would jeopardize the lives or property of people living in the neighborhood. What is the real reason for a 4-foot fence limitation in our side yard? Is it due to ordinance 1708-160, which is clear sight triangle sight distance? In this case, no traffic safety impairments exist at 4,000 Carrick Court. The proposed fence is located 125 feet from the intersection and does not extend past the rear of the house facing Carrick Court. Brookfield Drive is 36 feet from the fence. Therefore, the location of the fence does not hinder driver's view on Brookfield Drive or Carrick Court. COVID pandemic and resulting lockdown have impacted our self-awareness of our surroundings and the desire to have some level of privacy in our own home. As you know, crime has increased across the country. At the town meeting on June 6, 2022, Deputy Jason A. Halt explained, crime is rising in Emmitsburg, and he recommended having another deputy to cover the late evening shift. Lastly, in support of our appeal, I would like to share with you Emmitsburg zoning code 1704-030, interpretation in case of conflict with other ordinances. In interpreting and applying the provisions of this title, they shall be held to the minimum requirements for the promotion of the public safety, health, convenience, comfort, morals, property, and general welfare. That's all I have at this time.
Thank you, Valerie. Thank you, Robert. All right, Leslie, at this point, did you have any comments that you'd like to make right now, or should you just be open for questions?
I'm happy to answer any questions that you may have. I did note that there were citations to certain code provisions that don't appear to be applicable in this case, but I'm sure that we can address that as your discussion proceeds, specifically the MHIC references, which relate to building permits, not the zoning permits.
Okay, all right. Thank you very much. Zach, did you have anything else you wanted to add at this time before we close the meeting?
No, thank you.
Okay. All right, at this time, since there is no other testimony, I'm going to close. Yes.
Are we still open to testimony?
Well, we're going to close the meeting for discussion by the board members to discuss. At a point, can we ask the applicants questions as we do our deliberation?
If you have specific questions that you'd like to direct to the applicants, you can do so. But when they finish their presentations and when you finished your rebuttal or supplement to your presentation in this case, then that's it. If you would like to ask for leave to make an additional comment, it's up to Madam Chair to make the determination as to whether to accept it. Otherwise, you're going to be restricted to answering directed
Specific questions. Okay. Thank you very much, Leslie. I
You're
appreciate
welcome.
that clarification.
Could I make a short statement?
Yes.
She's going to be real nervous now because there's no paperwork here. I think as my wife had researched that all of you board members apparently have been out to our property and looked at the situation. I'm 73 years old. I go back, I was born and raised on a farm in Illinois where common sense still dictated many decisions. It seems to me that common sense, if you were at our residence and sitting at the corner or stopped at the stop sign in front of our house facing Brookfield, you would see that there are no line of sight or problematic areas that would be a problem to oncoming or cross traffic. That's really all I'd say. Like I said, I just would ask that maybe some common sense. I understand rules and regulations. I come from a law enforcement background. I come from Homeland Security, but it's sometimes the best choice is common sense. And if you've been there and you've seen it, that's probably the best thing I have for granting a variance. Thank you,
Thank you
Madam
very
Chairman. I
much.
appreciate it.
Yes. Let me close the meeting first so that we can open it up for deliberations among the board members, and then it will be specifically closed. And then if we have any questions directly of them, we can ask them at that time. So I'm going to now close the record on the discussions from the applicants. All right, Wayne.
Can you explain the impact of that road becoming a throughway rather than a dead end?
Yeah, so Brookfield, when we moved into the neighborhood 12 years ago, you entered Brookfield Drive from Tract Road and it dead ended at Irishtown Road. Irishtown Road was a dead end. You couldn't turn right or left or come from that direction. Now they've opened Irishtown Road for traffic to cross Brookfield Drive over to
Recently,
Tract.
right?
I'm
Just
sorry.
recently,
Yeah.
right?
Yeah, I think fairly
In the
recently,
last year, yeah.
since they started construction on
Yeah,
it.
that's a development that-
That's what I
Right.
thought.
And we don't want to have a lot of crosstalk. That specific question, was that, did you get the answer, enough of an answer that you wanted?
Yes, finish, I'm sorry. I
So-
want to know whether that was done recently, and it was. I
Yeah,
thought
that was
It
done
was.
fairly recently. So Brookfield Drive now has 2 points of entry from Irishtown Road as well as Tract Road. Our house sits right on Brookfield Road as well as Carrick Court, but the side of our property faces Brookfield Drive. We're kind of in the middle of Pembroke and Brookfield neighborhood. We're kind of right in the middle. There's a public sidewalk along the entire road of Brookfield. So there's constantly people walking their dogs, riding their bikes, running, walking, lots of traffic during school hours. It's just a very busy area because it's kind of smack dab in the middle of the 2 neighborhoods.
Mhm.
Whereas other homes, they may be off on the side street or closer to the front of Pembroke Woods.
Mhm.
So they don't experience the level of people and traffic that other animals. I think everybody in Pembroke walks their dog, except for us, because we have a fence.
Okay.
So there's a lot of people moving by our fence daily,
Mhm.
all hours of the day and night.
Right. Thank you.
Did that answer your question? sir?
Yes, thank you.
Zach, maybe you can answer a question from me in terms of, I believe that Brookfield was always intended to be open to traffic to Irishtown Road and has been in the comp plan for at least the last 20 years that I know of.
That's
Is
correct.
that correct?
Yes.
Okay. So that would have been something that would have been evident to the homeowners if they had requested the comp plan or looked at the zoning map. Okay, just for
I
clarification.
haven't lived there that long.
Yeah, we've been there 12 years, and when we moved in, there were no homes.
Right.
There was a big ginormous field behind our property. There were no homes built there
Mhm.
until very recently. So we would have no reason to believe that they would open up Irishtown Road. And originally, when they opened up Irishtown Road, you could turn out of the Pembroke Woods development onto Irishtown Road, right and
Mhm.
left.
Mhm.
But you couldn't
Couldn't.
turn off of Irishtown Road onto Brookfield.
Back in, correct.
But they've removed that one-way sign. So now it's traffic coming both ways.
I understand.
Okay.
Okay. So what I'd like to do now is open it up for discussion by the board. We'd like to get your general impressions of the decision. I know I was there. And I believe that probably every one of us has been out to the property and seen it. So,
And so before you open it to general discussion, could I ask a somewhat rhetorical question?
go ahead. Of us or of the planner or of the lawyer?
Our attorney and our staff, but also Mr. and Mrs. Turnquest. And the question is rhetorical from the standpoint that you've made a lot of declarative statements that as a homeowner, I feel your pain. I wouldn't, as a homeowner or as a member of this board, try to dispute them. But my question is, that's not what we're here for tonight. And I want to make sure that I understand the rules of engagement. So there are 3 things that we have to establish, and we've heard Zach say them, and we've heard you guys, Mr. and Mrs. Turnquest, validate your understanding of them. And so if I make a statement that some of the impact of the legitimate concerns that you've made is unremarkable, that doesn't mean it's not valid. It means that relative to proving beyond a shadow of doubt, our job here tonight is to determine whether or not there are exceptional or extraordinary circumstances. And so I simply want to point out and have us all verify that whatever the outcome is, we're not telling you that your concerns are not legitimate. We're telling you only that they're not objective or measurable in terms of the extent to which a fence will improve erosion or noise, security, wild animals. And so you make and this resonated with me. And Valerie, I admire the work that you put into this to find the truth that sound waves do and can be attenuated by a fence. But it's also relevant to frequency. And so the higher the frequency, the more line of sight the sound waves tend to travel. And therefore, it's only the low frequency sounds that will bounce around and find their way through the fence, and very high frequency sounds, perhaps, unless they're directed right at a very dense material, it won't be attenuated. So all I'm getting at is my concern is whether or not the information that you provided, which is excellent, defines beyond a reasonable doubt exceptional and extraordinary circumstances.
And this is a discussion that technically you're having with us as board members right now. If you had a specific question for the Turnquist, then that would be fine. I appreciate the work that you guys both put into the application package. This is a lot of work, and I think you did a very good job on it, but we need to make a decision on these three findings and whether the variance meets those requirements. So,
And that is my question. Do I fully understand the purpose of this meeting tonight? And that is directed at these 3 points and no other.
Yes, excuse me. Yes, that is correct. And really, the way this works is that if you don't meet the first criterion, if you don't determine that this property is unique in nature such that a variance from the regular code provision should apply, it's, you don't pass go. All right.
Right.
So that's really the first issue. Is the property unique and unusual from the surrounding properties? And is it that uniqueness that causes the zoning provisions to work a hardship on these particular people?
correct.
So that's step one. And if you get through step one and say, well, based on the testimony that we've heard and the facts in our inspection of the property, then you would go through and make the remaining findings.
Mhm.
So that's the process.
And
So I hope I answered your question.
You did, but unique is not different. Unique is a step beyond. All of the lots that Zach pointed out,
Mhm.
there are differences, but the differences are what I would call unremarkable. And I don't want to feel as though I'm intentionally trying to insult anybody
Sure.
by making that point.
No,
They're all different, but whether or not they're,
yeah, is this, right, is this particular property so situated that it faces an unreasonable hardship in the context of the surrounding neighborhood? That's really the question that you're looking at, as you put it. That would make it unique.
Can I hear some thoughts? from
Thank
the
you.
other board
Certainly.
members?
I'm, to be honest with you, a little concerned because I think that the point that the applicant is making is a valid point. And so I tend to disagree with my fellow board member on this. I think that their experience is something that really matters here. They can't define it or measure it objectively, but it's clearly an issue for them. And I think that living there would be a sort of a, call it if you like, a good test of whether or not this was a problem for them. And they have a change in volume, traffic and persons running around and things. And I think that weighs on people and the residents suffer for it. And the question is, well, what can be done about it, if anything? And our role here, I think, is to determine whether or not there's anything in the code that would allow for them to be able to keep a fence that's 6 foot tall. I'm a little concerned that the builder didn't make this clear and didn't apply for the permit and take care of them. I feel like that's a sort of an injury to the applicant, but they're suffering from that now. I also don't want to see the applicant incur a lot of excess costs in remedying this because they paid the bill for the fence and they did it with the best of intentions. So I look at this as being an applicant that is sort of at this point suffering for the, call it if you'd like, the text of the code. And I think that we should probably consider a revision to that code that would allow them to keep that fence.
Unfortunately, we can say that we think that a revision to the code is necessary, but we can make that suggestion. It's not up to us. It's up to the commissioners.
That I understand.
And I'm concerned. I understand the hardships. I'm horrified that the contractor would not know to get a permit from the town.
Or the HOA.
Or the HOA. But that again is not something that's within our control. So maybe, Dan, I'd like to hear any of your concerns or thoughts on this.
Well, I have a couple of things. Now, part of the problem is this replaced a split rail fence that's been there 15 plus years,
Mhm.
which was within code because it's 4 split rails, only 4 foot high.
Right.
I'd like to ask a question to the Turnquist. Is there a reason the 6 foot height is required to you? I mean, with a 4 foot fence there, the same style you have, that 2 foot was chopped off, would that suffice to meet your
Well,
issues with the pets and
even
children and so
with-
forth?
I'm sorry to interrupt. Even with the 6 foot fence, if you're standing across Brookfield Drive, you can see us sitting on our deck.
Mhm.
So a 4 foot fence would do nothing to help mitigate that. And in terms
I'm
of
more
the
concerned-
houses that
yeah,
they just built behind us, they are much higher,
Right.
much higher. So even with a 6 foot fence, they can clearly still see into our yard.
Mhm.
But the 6 foot fence does give us a little bit of security, a feeling of privacy, to ensure that our animals aren't jumping over a 4 foot fence and, running out into the street. And hope, and other people walking by that my dogs aren't running to the fence, like they're going into attack mode every time somebody walks by.
Okay. And at some point, we need to make sure that we're asking specific questions and not having a back and forth.
Oh, yeah, I'm
again
just trying to
on it. So
clarify.
you were just clarifying.
Clarifying
that
whether,
question.
if cutting it down to 4 foot would make a difference or not, is what I was trying to clarify.
Right, right. And my concern is literally setting precedent for other people to have 6 foot fences in their front yard. the wording of having a corner lot have 2 front yards is a little concerning. And can I propose something? I mean, you'll stop me in the middle if I propose something that
Sure.
seems
You-
outrageous.
No, I think you may be proposing something that I was going to say. But
Oh.
so why don't you propose and I will tell you.
Before you propose,
You don't know what I'm gonna propose. I might propose marriage. No, I'm
can
sorry, I'm
we
being sarcastic.
logically validate the reason that Brookfield and Pembroke have a situation where there are 2 front yards?
Mhm.
On corner lots,
Yes, ma'am.
yes.
It's not in just Brookfield, it's any corner lot.
Correct. But what I would like to bring to light, and at the risk of, again, stating the obvious, I don't think it's that obvious. So I want to make sure it is stated.
Mm.
But with a corner lot, there needs to be an objective, measurable methodology to ensure that all homeowners with corner lots are treated the same way. And
Mhm.
therefore, if 2 sides of a property are seen from street view, they're called front yards. Zach, am I missing anything?
That's correct. It is defined as 2 front yards. That's the way your code is written. That's the way several other jurisdictions' codes are written. When you have 2 abutting streets and a lot literally at the corner, you have 2 front yards. You have the front yard that abuts this street, and then you have a front yard that abuts the other street.
And so with that said, what I would add is what a solution would look like. As good as the work that you guys did, the only place that it arguably fell short, and this is one man's opinion, there's 4 people and they're all going to vote on it. But, you know, you could take another crack at it if you were so inclined. But a solution would be to recognize the reason why there are 2 front yards on corner lots, and come and know that the reason is to have an objective way to treat all people fairly and equally, would be to come back with a solution that improves on what was and has been created long before any of us were here.
But I think the clear sight triangle code, I'm sorry, does address the issue of a corner lot. That's already in the town code,
The,
the clear sight triangle.
correct,
Yes.
correct. And that was a condition if we approved
Correct.
the variance. All right. I was going to suggest another completely different proposal and maybe a way of
Why don't you go into your proposal and let's work off of that?
Is there a way to, I know we did it once before. We actually put off, not postponed a decision, but we made a decision and said you have 6 months to implement a solution for this, wherein the solution, and I'm just spitballing here, might be to say, let's have the town look at the changes in the circumstances and possibly rewrite the requirements. Possibly if a corner lot is on an arterial road or a road that's opened up to through traffic, or, I mean, most of our roads in town are 25 or less, right? Brookfield is probably going to be more than that, I would think, because it is a main thoroughfare. So is there a way to create a space in the code for suggesting something to the commissioners and putting this decision off, because we can say that we'd like more evidence on this, right?
When you said 25 or less, I didn't understand that.
25 miles per hour
Ah,
or less. I'm just thinking of main arterial roads.
So there are two ways to look at this. One, which is what I thought you were driving at, and I believe is what you're driving at, is a presentation of a text amendment to the zoning code
Correct.
to address the circumstance of homes that abut arterial roads.
And I don't even know if that's the correct definition.
Well, and yeah, so
That's
you,
what I
you could,
mean.
you could say, I mean, well, somebody would have to make a proposal, but, and the text amendment could come from either the commissioners or from the Turnquists through an application, because there is a process to do a text amendment, as you know, but you could say on roads with, you know, speed limits in excess of blah, 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 or whatever it is that you determine is appropriate, provided that sight distances are not impaired. You know, you can seek and basically to treat a side or a front yard as a side yard, if you will, that would then govern the height and the location of the fence. So
Right.
that is certainly something that would be an option. And if the applicant seeking the variance were to agree that they would want to defer a decision until such time as the commissioners had the opportunity to consider a text amendment, then that's something that they would have the ability to do.
Right, because we're not saying that the commissioners would agree to that.
Well, no, because that's not your
can't.
job, right? The commissioner's job is to legislate and your job is to make determinations with respect to variances, special exceptions, and appeals from decisions of the zoning administrator.
Correct.
So that's one thing. I guess the other thing, and I don't know the answer to this, is whether the opening of Brookfield and the speed limit are such that it does in fact create a difference.
Right.
In this lot. So it could, in fact, depending upon how you analyze this situation, create the circumstance for the need for a variance, because this property would be different than the others, right? I don't know what the evidence is on that front in terms of the speed limit on Brookfield, or what the intended future speed limit is, or just exactly what in the world is going on Brookfield Drive at this particular point. I mean, obviously speeding doesn't count.
Right. No.
All right.
So have to
So
be a post.
it would have to be, I think, a posted limit. And if the board were inclined to consider that a distinguishing feature, then that's certainly within your realm. I don't know if you have the evidence in the record this evening to do that. I haven't heard anything about
can
it.
I ask another question?
Sure.
This one will be short. If that is actually a very interesting idea,
Mhm.
and there's a lot of merit to it, but Brookfield is not the only road in that community. And the community that I'm talking about is Pembroke and Brookfield. So Timber Mill traffic has increased and so has speeds. Brookfield has. Irishtown Road has already had a fatal accident as the result of changes that have been made. Can we make a recommendation to have people look at this and look at the overall potential issue and circumstances, and not just Brookfield Road?
Oh,
They're all adjoining roads is what it comes down to. Brookfield joins Irishtown and joins Timber Mill. And therefore, all three road traffic patterns have changed considerably.
But they're all not corner lots.
the corner lot is the issue where you have two front.
Right. It would only pertain to the corner lot situation. So I would assume that there are not 200 corner lots in Pembroke.
And we have, it's in the code
Yeah.
that 6-foot fence is fine in the back and
Right.
the side. So if we were to redefine on a corner lot that faces arterial, and again, I don't know if this is possible or if the commissioners will agree to it, but that way we might be able to come to a common sense solution that would help other homeowners who may be faced with the same issue.
Well,
And I agree with you, but there's another circumstance that has not come up. And Zach, I'm going to apologize in advance. In the event that you didn't want this brought up. And I don't know if you did or not, but the same situation exists on Brookfield where there are homes that have what you're calling an arterial road on the front yard. And instead of the side yard, because it's a corner lot, it's the backyard. Same circumstance. Two sides of a lot are facing or are parallel to what's being called an arterial road.
But
Therefore, what I'm suggesting kind of validates what you're suggesting, that we need to take another look at it. And when I say we, I'm talking about the town and the people who are given the responsibility to make these decisions, not this board.
But those homes that you're saying are facing, those are backyards that are on Brookfield Drive.
They are, but to the point that the Turnquests are making, and please don't quote me on this because I don't run around the neighborhood with a tape measure.
I actually did this afternoon.
But there are homes that back up to Brookfield
Mhm.
that may have fences that are larger or taller than 4 feet.
Well, backyard, 4 foot is
Backyard is
legal.
okay.
Over 4 foot, 6 foot are legal in backyards.
That is my point, but they're facing an arterial road. So what
It
is
doesn't apply to
the,
face arterial roads.
I'm
Arterial
sorry?
roads- Arterial roads don't have an effect on what we're discussing here. We're discussing corner lots. The arterial road is not it's not what decides what's going on here. It's the property, the property has defined as its front yard, which is a rule, at least in the case of corner lots. What they use as the front yard is the shorter of the two lengths of the frontage. That's because they're the front yard. In their cases, it's Carrick Court.
Dan, I'm not discounting what you're saying, okay? But what I am suggesting is the 4-foot fence is as much of an issue as the front yard. Because a solution is to cut the fence down to 4 feet on the side that is also a side yard. So they have a front yard, they have a backyard, they have a side yard. Then they have a side yard that is not only a side yard, but it's a front yard.
Actually, technically, they have 2 fronts and 2 sides. That's a whole nother issue.
That's exactly what I'm saying. But the definition, I believe, is driven by the fact that they're viewable from an arterial road.
No.
No, not that I believe.
What is the reason then? I thought that the backyard of a corner lot can be seen from the sidewalk, and therefore it is called a front yard and a side yard. And I could be wrong. I'm learning.
You
just
are,
like
yeah, you
everybody
are wrong, respectfully. The way this works is that it is the lot itself that borders the streets. Okay, and so when you look at the cul-de-sac, for example, in Brookfield, there are backyards that theoretically look out onto Brookfield Drive, but they're not on the street because there is no connection. Okay, so that's a totally different
What
thing.
is the
So
definition of a connection?
The streets aren't
the
connected.
street.
The streets aren't connected. So it's on a, yeah, it's not a corner. And so the issue here is if you have a lot, and if you actually look at their application, you can see it.
I've seen
It's-
it and I understand what you just said.
Right. And so lot 1 is a corner lot. Lot 23 is a corner lot. Lot 2 is not a corner lot. So if you look at their, the blow up that they have of the plat, that shows pretty clearly what a corner lot is. And because it is a corner lot here, you've got the 2 infamous front yards. And that's how it's defined. I mean, if you wanted to defer and talk about a text amendment, which would require some crafting. I mean, you'd have to think long and hard about it because this, this situation is not, it's not necessarily unique and I think it can be cured by a text amendment, but how you cure it and preserving the ability to, see the streets safely, to keep kids from, darting out from behind a tall fence and getting flattened by a car or something like that. Then that's certainly within your realm. If the applicants want to have a decision tonight, you have to make the decision based on the evidence that's before you.
Correct.
So.
When you said, did you say text,
Text amendment.
Yes.
amendment?
Correct.
So that's literally changing the text
To
that
the zoning.
defines the corner lot.
That is right. It would be going to the commissioners. Well, after a recommendation by you on, is this a good idea or a bad idea? Then the commissioners say, well, yes, we think this is a good idea, or no, we like our code the way it's written and we're not going to change it.
You
So,
can't just change it for Pembroke and Brookfield.
no,
We
and
would
that's,
have to
No, it's
change it.
okay.
yeah, and that's the other thing I wanted to say, because there's confusion about, well, what does the neighborhood mean here? And that became apparent during this discussion. This is not a Pembroke centric decision. This relates to all lots, all R1 corner lots within the town of Emmitsburg. Right. And that's the zoning, that's the context in which you review this application.
Right.
So
That's a very good, clear point. Thank
Yeah.
you.
you're welcome.
And we have to think whether it has further consequences and implications for annexations. So we really have to do this with care. But it's a possible solution.
You guys made good suggestions, better than anything I brought up.
Well, no, it's important that we want to have a full-bodied discussion where everybody feels comfortable bringing out ideas, because our job is not just to, our job is to hopefully come up with solutions that will work for everybody in the town. We, obviously we all studied this. And we're looking for common sense ways. Thank you for.
And I think fairness is important here too.
Mhm, mhm. We want to make sure that we can do this the right way. So Zach, first of all, I guess I would need to ask the Turnquists if they need a decision tonight, right?
Yes, so if the Turnquists request a continuance, unfortunately, we have to charge, there is a fee of $150. If the board asks for a continuance, it's free. So I just want to make sure that's clear,
Thank you.
that we have to follow that rule, that policy
I
of the review
wasn't
fees.
clear on that.
You wanna take a
Thank
motion?
you, Zach.
We would need, do we need a motion to ask for a continuance? We probably do. Do I hear a motion to
Hear a
ask
motion.
for a continuance?
Motion
I
to
second it.
continuance.
Okay, so you made the motion.
Scott seconded.
Scott seconded it.
Mhm.
All in favor signify by saying aye, that the board
Aye.
is requesting a continuance.
Okay,
Aye, the
and-
ayes have it.
And then the next thing that I would recommend to the board is that you, if you can briefly, state the basis for the request for continuance, and we should talk
Right.
about a time period.
Right.
So it doesn't act, just expand into infinity.
Does this require findings of fact as we would have to do for a variance request? No.
No, it
No,
doesn't
just-
require, I think that if I were in your shoes, I would consider, that the applicants has raised some varied and important questions that you think require further consideration and research, and that
That
you-
have implications for
Right.
the entire town.
for the entire town.
So
And
we would like to
I'd say continue the
request
matter
a
for 6 months.
continuance
Yeah.
for 6 months to suggest a text amendment to put the current code enforcement issues on hold for 6 months, right? Because there's a
Okay.
there's a fee, I think, associated with this. So
Right, that it would
that-
be stayed.
we would have to stay the code enforcement issue and work with Zach to suggest potential draft code language, code
Mhm.
zoning changes to that particular issue where corner lots have been defined as having 2 front yards. And we need to address the issue when there are arterial roads where some of these issues could come up. And we
Throughout
need
the
to make it
community.
for all R1.
Right, throughout the
Right.
Well, and actually it's
the-
throughout the town, because Zach made the valid point that corner lots are corner lots, no matter what zoning district
Oh,
they're
okay,
in.
it could be VZ.
Yeah,
I'm in a corner lot.
Right.
In a VZ.
right. So,
Yeah.
so that has to happen. And I think
right.
that, the other possibility the board may wish to consider is that, if the commissioners choose not to adopt a text amendment, if you want to allow the applicants leave to submit additional evidence in support of their application, that they be permitted to do so, but that is certainly at the board's
Without,
discretion.
that they be permitted to.
Basically
resubmit
reopen the-
without- Right.
Right, to reopen the evidentiary portion, and if there's other research that they come across in the interim period that they'd like the board to discuss,
Correct,
that they be permitted to do so.
correct. All right.
And do I need to make a motion if we wanted to add that until the 6-month continuance is resolved, we're not asking the Turnquest to take any action
No, that's a stay.
with the fence that is already in place?
Right.
Right, that would be included within the stay of enforcement
Of the
during this
enforcement.
6-month period. And if you wanted to make a separate motion with respect to that, it would be appropriate.
And I know you're not bashful. so please
I don't
feel
think any of
free
us are.
to tell me that, no, Scott, you're out of line here. But I think the Turnquests have made a number of valid issues, and I think we've all acknowledged that. The thing that I'm having trouble with, because I'm hard-headed, okay, is the fact that a lot of the issues have to do with the change in dynamics of the roads.
Mhm.
And it's because of the new houses, more people, more cars, thoroughfares that weren't there previously. Can we make a motion here that the text amendment, is that what it's called?
Mhm.
That we're talking about, look at anywhere in the town where the same thing is happening, that the circumstances have created different traffic patterns. I don't know that we would be here talking about this if, no, We would be because
We
it's a
would be.
corner lot, but
We would
we
be.
do keep bringing up the roads.
Well, I think that the roads were brought up because that was the distinction that the applicants relied on.
But
So
you-
it's sort of a self-fulfilling.
You made a very important point
Yeah.
about, a kid opening a gate, running out of their
Yeah.
back, out of the yard or through the gate. I don't
Yeah.
remember what you exactly said, and getting hit by a car.
Yep.
And what I was talking about, where there are houses that back up to a road that the traffic patterns have changed considerably. That could happen for the same reason.
Well, yes, and I think that one thing that's important, and Dan had alluded to this earlier, it's corner lots. And we have to be really precise in our terminology, because the back of a lot is the back of a lot, period. End
The
of
back of a
story.
lot is fine for us.
And the back of a lot can have a 6-foot fence. And the reason, the town doesn't have 6-foot fences in front yards is that you don't want it to start looking like a gulag, among other things, because then it winds up creating barriers to, and, it's not neighborly, let's put
Right.
it that way.
Right.
Right. And I think that you can understand their perspective and their frustration. But it's also important to remember that the town did not cause the situation. We have an uneducated HOA. We have an uneducated fence contractor, and everyone is charged with knowledge of the rules.
Mhm.
Whether they know them or not, you are charged with the knowledge of the laws. And so, we sympathize. Fences are not cheap. They're a monumental exercise. But if you're going to have a text amendment, it does have to work for the whole town. And as I
Mhm.
said, if they take the time to show or to bring additional distinctions before the board during this interim period, then it makes sense. Are we limit, excuse me, there's one question I have. Is there a limit on the amount of a continuance in your code? Okay. Yeah, I just want to make sure that we're not blowing through a 60-day or some type of limit, because I didn't bring the whole code with me.
I know that at one point in another Board of Appeals meeting, we did do a 6-month continuance. So
If you've done it before,
I'm
chances are it's
fairly
fine.
certain
Yeah.
that
One
was
other
allowed,
point.
but a good idea to check.
Relative to 6-foot fences.
Mhm. Yeah, because this is probably something that needs to be discussed when we're talking with Zach about suggested language for the new.
All right, I
text
think
amendment.
we think you're good with 6 months.
Okay, good. Thank you for checking. Are there any other questions or comments?
Yes, a comment.
Yes.
Just because the town ordinance allows 6-foot fences doesn't mean that an open community like Pembroke or Brookfield, their HOAs have to approve them.
That's
And
right.
right now, our HOA is thinking about the use of 6-foot fences where there's a real need, like you brought up the fact that, when you're on your deck, people can see you from the road anyway. So maybe putting a 6-foot fence on the sides of the deck the way a townhouse would.
Mhm.
All I'm getting at is it's unlikely, at least with the board that is in place in Brookfield today, that 6-foot fences would be allowed to encompass an entire backyard because of guidelines.
Yeah, well,
And my guess is it's no different in Pembroke.
yeah,
A
that's out of
5-foot
our
fence you could
jurisdiction.
do,
Yeah.
6-foot, I'm not sure.
Fences are permitted.
Okay, I stand corrected.
Because their current fence is 6 foot all the way around and it's entirely around the lot from, it starts at their, well, it doesn't now. The split rail started where their side door was. I think they've moved it up a little bit of this new one and goes clear around to the tree line, then along the tree line, and then back up to the rear of their house again. So it's 6 foot all the way around that what in most houses would be a rear property,
Right,
rear yard.
right.
Understand.
So it's a good point, though, Scott, to bring up the distinction between HOA, which we have no control over. As long as the HOA is in conformance with the town ordinances, then
Right.
we're all in good shape.
Well, I have a question on that. If the HOA stipulated that it would be a 4-foot maximum and we allow 6 feet, those are still compatible because the HOA can operate independently as long as it's not injurious to the town, right?
That is correct. The
We do
HOA
that
can have
today.
more stringent
Right.
restrictions than the
Mhm.
town.
Right.
Yes.
exactly. So that, it doesn't matter if one HOA doesn't like a 6-foot fence or what, we could still pass a code or text revision that would allow 6-foot fences for corner lots.
For the, right, for the community.
Right,
for the whole
community
community.
wide.
So I believe that we have no other decisions to make this evening.
I'll make one other comment, because I'm not bashful.
I
Thank
know.
you very much for the opportunity to make this a win or learn situation. There is no loser. So you made a lot of good points. I certainly learned something. Thank you.
Thank you all for listening.
Sure. Do I hear a motion to close the meeting, adjourn the meeting?
Are we allowed?
Yes,
You are.
yes, yes, please.
Go home.
Motion.
Adjourn the meeting.
Motion to adjourn.
Thank you, Wayne. Motion made by Wayne Slaughter, seconded by
Second.
Scott. All in favor signify by saying aye.
Aye.
Aye. Hot dog.